Yo guys, what is up? Andy here, back at you with another video. And today we're going to be talking about what a bill is. Obviously, recently the Cannabis for Private Purposes proposed bill came out and has been submitted to Parliament. So it's important to understand what exactly this means. So this is not a detailed look into the content of the bill. We will be getting to those. This is just a look at understanding how a bill goes through the Parliament and through South African legislative requirements, and we've got Schindler's attorneys who have offered to help explain this process to us. This is also part one of two other videos. So we've got Myrtle Clark, she's also offered to give her opinion. That'll be linked below when it comes out. And then Jeremy Acton from the Dagga Party has also offered to give some info on the proposed bill. More on the contents though. So anyway, without further ado, off to Zoom meeting with Stefan Bezuidenhout, and let's check it out. Hi Stefan, welcome to this short interview. Thank you so much for joining us today and for answering some questions for us.
Thank you for having me, Andrew.
I'm going to jump straight in. Obviously your professional background, you know the processes surrounding this bill, and for most people, we don't even really understand what a bill means. So cabinet's processed this. They obviously were satisfied with the bill, and now they've approved it for the submission to Parliament for processing. What does that mean to most people? What does that mean in the industry?
Thanks, Andrew. Well, it's very important to understand that, first of all, this is not official law yet. This has only been a draft bill. There's still a lot to happen, and depending on the cooperation of the different governmental institutions, it will depend on the timeline that it's going to take for this bill to get passed. Because traditionally, when you create a law, and this is in terms of Section 75 or 76 of the Constitution, you'll usually get private and public laws as well. Private laws being something more applicable to universities, which is not applicable to everyone, and public meaning, the minimal drinking age, which is applicable to every single South African. So we've got the benefit that this is a public law, not a private law, because they just have to inform the public of these hearings, where in a private regulation, they will have to actually reach out and give notice to all the parties that will be involved. So we do have the benefit that this involves every single individual South African, and therefore there's no notice to be given, but the public participation is a bit more easier. Now, the consideration is basically in two phases. You get your principal consideration, and then you'll get your detailed consideration. You'll notice there was two documents that was released. The one is more like a reasoning and the summary. That'll be your principal consideration. So this was published. Now this can all obviously be, this contains the background, the purpose, the principles that will be involved. And then you get your detailed consideration, which is more of an analysis of everything that is contained in the bill, which will be the one that we've seen ourselves. Now, before a bill can become law, there's about 5 or 6 stages that it needs to go through. First, it needs to be considered by both houses of Parliament. This includes the National Assembly and the National Council of Provinces. So what will happen now, this bill has been approved by Parliament. It's now going to be introduced into the National Assembly. Now, this can only be done by a minister, a portfolio committee, or an assembly member. And after this, it's now discussed and amended by the portfolio committee. Now, during this process, there is supposed to be public participation, but I will get to the public participation right now. Let me just first quickly finish how these laws actually come into place. Now, after it's discussed and basically amended by the portfolio committee and having some public participation, it'll go to be debated in the National Assembly. Now, there's obviously also public participation involved. A lot of the questions is, how can we get involved? There's two ways. You can give some written submissions, if you're an interested party, or the committee can invite you to give oral evidence, to go and give your speeches yourself. Now, only after it's been debated in the National Assembly is it tabled in the National Council of Provinces. So they then discuss by the select committee, and it's debated in the National Council of Provinces. Now, one of three things can happen. So this is now only after we've given our comments, only after they've made the amendments, and it's now at the National Council of Provinces.
Mm-hmm.
They can either pass the law, say, listen, we're happy with this bill and the amendments that you've made, and it automatically will then just go to the president to be signed, and as soon as it's published, then it's official law. But they can also come back and say it's passed on the provisions that you're making certain amendments. So then they will have to go back, make the amendments, put it back to the committee, and see if they can pass it. If the National Council of Provinces decide not to amend it, or they're not happy with it and they completely reject it, it goes to a mediation committee. The mediation committee will then see if there's a compromise. If a compromise is reached, that compromise is sent to the president for approval and for signing. And if there's no compromise, unfortunately, the bill can't be passed. So it's quite a lengthy process, and it all depends on, you know, the schedule of the legislature, how COVID is now going to impact all these National Assembly meetings. So it's impossible for me to give you a timeline on this, but it is nice to know that this is more or less, you can say, what the government had in mind when it's composing its legislation. So it's beneficial to know that at least for now, we more or less have an idea of where the government stands and where they intend on proceeding with this.
Yeah, no, that's really, really interesting. So it does go to, I mean, stand again that it's obviously it's not passed yet, and I think that's the key determinant. This doesn't change anything at the moment, so a lot of people are very confused, and they straight away they're going to start pulling out plants and this and that, thinking that they can't have this many and all of those things. So that's obviously a good thing, and that this process now that needs to begin is obviously a lengthy process, and there will be opportunities coming up in this process, as you said, like giving your public opinion and all of these. And that sort of brings us to the next question, which is the public being involved. I mean, so there's obviously different sides of the story, and on the activism side, they say that the public opinion isn't as loudly heard as it would like to, or as they would like it to be. But there is a formal process where people can oppose this, or is it opposing, or do they just give their comment?
It is definitely a process. How formal the process is actually quite debatable, because the bill that's been published now, you call it a green paper. You know, it's the first draft. After some comments and amendments, it only becomes a white paper, which is then a broad spectrum of the government policy. And this also has to be approved by cabinet before it's submitted to parliament. Now, when it comes even to the constitution, it's very clear that for a democratic society, public participation in the creation of this legislation is absolutely essential. That's why in section 59, it's the public access and involvement in your National Assembly, which is where some of the public participation will lie. In section 72, you've got your public access and involvement to the National Council. And then section 118, which isn't really applicable here, is more for the involvement in your provincial legislature, which will be more from province to province. So it's clear from these three sections in the Constitution that you should be able to, and it's clearly defined that they should encourage this public participation. Now, unfortunately, it's not as easy as they're saying, you know, it has to be within these timelines. These are the newspapers that it has to be published in. So you're going to have to do some digging to find out where and when these kind of things will be, because you know, this can be published on their websites. They sometimes publish them in newspapers. You can reach out to them, but for them, they're supposed to have public hearings by provincial committees. So you should then, well, they'll have to organize these public hearings. It should be published on the provincial websites. And they invite stakeholders, usually to come and make written submissions or oral submissions. So it's very, very dependent on them as well, because I know it's very frustrating for us as well, having represented the Dacha couples / Fields of Green for All. Now we've got a proposed bill, and Myrtle wasn't approached once by government, or I've seen the video of the CDC where Gareth Prince also made his voice heard, where they didn't just approach us. So, coming from a constitutional point, yes, definitely, it should have been much easier. I do believe that they didn't fully reach out to us and get our thoughts and comments before just drafting this thing. And also, but yeah, so that's just a feeling, but that's unfortunately the way that our government sometimes operates. And our intention is then now, even though we didn't have that participation in the first draft, that we will make our voices clear and our recommendations going in now, having the public opinion or some public participation in this. So hopefully, if they don't reach out to us as a stakeholder or an interested party, we'll definitely be making some pretty serious written submissions as to how they won't consider us a stakeholder in, or why they didn't allow this public participation, where the entire reason for this was us taking them to court. So why not consult with a party that took you to court for, and this huge Fields of Green for All? So yeah, public participation is a bit tricky in the sense that in terms of the legislation, it should be as easy as 1, 2, 3, and your voice should be heard. In terms of practicality, you might have to do some digging, you might have to phone around a bit. We'll also obviously definitely keep the public informed, when and where these things go down. So you can definitely just have a look, but the best way is to just go on your provincial committee or your provincial legislators, maybe their forum or website or whatever. You can either try contacting them, but they should publish when they will be having these public hearings, and that's open to the public.
Yeah, no, that's actually that's really sort of rest assuring feeling, or I mean, okay, sure, the government didn't consult to the level that we wanted on the initial proposed bill. That leaves us in a shortfall position now, because obviously we only now have, essentially, we either rely on the government to not pass it and nothing happens and we all, it starts the process again, or we wait until the public gets their opinion. And if it is public opinion, I suppose this is just coming to mind now that there's a lot of hopefully this opportunity for the public to get involved is accessible for the public. As you said, if just the mere site that we have to do digging could be a problem for a lot of people in lower income families or less access to technologies and all of that. But anyway, I suppose that's not the problem.
I think if you're not an old 420 person, so to speak, I'd say that you might have to do some digging. People who are usually have an interest in the plants, they follow enough social media accounts as well that somehow it should end up on a platform. But it shouldn't depend on us to share this information. It should be really more publicly available. But the Constitution does set out that they have to take into account and encourage this public participation. And it goes way beyond that, in the sense that there was a Pharmaceutical Manufacturers Association case in the year of 2000 where everything went well up until the point where the president signed into this bill. It was over the control of medicine. And even after everything was passed, it was reviewed on constitutional grounds and set aside. So it's very important to know that there's a lot of things that can happen during creating this legislation. It is not as simple as we've got this
No.
bill and we're all going to make our submissions. And it also leaves the question now what happens in the meantime, because the deadline for the 24 months is coming up next month. And there's
Yeah.
obviously no way I can guarantee you that this bill is going to be passed within a month. Obviously, it's going to take a bit longer, and that leaves also the interim position. I think.
Yeah, that's also a massive thing that's been circulating is, I mean, obviously it was granted 24 months in order to sort of come back to the table with is this the, so I suppose, is this the proposal that they were told to come back with in the 24 months? And then as said, I mean, what's going to happen on that day of, I believe it's the 11th of September. Does that mean what happened 24 months ago goes out the window, or
So
yeah, if you can.
the Constitutional Court judgment didn't go as far as to telling Parliament exactly what it should be doing. It only told Parliament you've got 24 months to amend these legislation to be in line with the Constitution. From what we're seeing is they kind of did the bare minimum. They didn't
Yeah.
really, from our perspective, see all the economic opportunity or see the need in the rural areas for people to have access to this. Or so for me and for us, we are of the opinion that they didn't really go the extra mile. They kind of did the bare minimum, but also that's only what they had to do. The court mandated them to fix this. The court didn't give them the order to fully expand on a commercial side of things. So the discretion was in their hands, unfortunately. They did the minimum. If we now feel it is unfair, and after all the amendments, we still feel that the law isn't quite fair, then you'll have to take the Parliament back to court.
Yeah.
So yeah, that's definitely. But in the meantime, let's say the 24-month period expires now next month on the 18th, if I'm not mistaken. Then we're not going back to a position prior to the judgment. So the position that currently stands in terms of the judgment will continue to be the interim position until this bill is passed. So
Yeah.
luckily, we're not going backwards. If the deadline isn't met, there's unfortunately not an executive or authority that's going to go to Parliament and slap their wrist or punish them now for not meeting the deadline. If they still didn't publish a bill after this date and we haven't heard anything again, what can you do? You have to go back to court and say, listen, again, they didn't comply to the order of the 24 months, etc.
Yeah.
But in the meantime, you can rest assured that if this time now passes, until the time that the bill is passed, the constitutional judgment will continue to have effect, and all the rights that it gave you will not be impaired or affected in any way.
That's extremely important for most people to note, is that, yeah, I mean, it's a massive peace of mind as well, is that they can't backtrack on something that was deemed unconstitutional. I mean, those laws that they were supposed to amend were stated as unconstitutional, and true, they haven't brought back new specifications and new amendments, but those, they can't go and now start, okay, so 24 months pass and it's like, okay, now it is constitutional. So, okay, so we've got that on our side.
And
that is
I've got to say, in terms of this public participation, as difficult as it is in those sections in the Constitution, it's not only that help us, but in 2006, let me just get the name right. In 2006, there was a case of the Doctors for Life International versus the Speaker of the National Assembly, where it was again they felt like there wasn't enough public participation in the drafting of this legislation, and the Constitutional Court, again highest court in the land, came back and declared those legislation null and void. Said go back, go talk to the public, get their opinions. So we'll see how this plays out. If they really try to do this hush hush, we can always try and take them back to court on the same principle to say that, like, you did this, didn't have public
Yeah.
participation, and that is grounds for a review of the entire setting.
Yeah.
So that is hopefully some of the. It hopefully won't get to that. Obviously, nobody
Yeah.
wants to fight that battle in courts. But it's good to know that, the law is developed in such a way that it does protect your rights. We've got a great constitution. It's just the way it's implemented isn't always up to standard as the
Yeah.
constitution itself.
Yeah, and of course that leads to things like, I mean, the time lapses and the processes, and as you mentioned earlier, now with COVID as a possible scapegoat for any sort of things, and it leaves all of these things in the air. But yeah, key takeaways is that it's, the Constitution isn't, they're not going to revert back on our judgment.
No.
This isn't going to happen overnight, which is quite a relief. And basically, and I suppose there would be fair warning before something like this would. So say it gets passed, and do they date it as a point where it would get passed, or would it
Yeah,
sort of
so
just?
usually after the president signs it and it is published, it will get published in the government gazette, newspapers, and on that date of the publication will be its official dates that it will commence.
Enacted from
Until
now.
then, you can't rely on this as law. You'll still have to rely on your constitutional court judgment
Yeah.
until this is now passed. But the gist of it is the same position will apply going forward. We do have some interesting takes from the bill. We're not entirely opposed to everything contained in it. There's certainly steps in the right direction, but when it comes to certain things like quantity, we do feel they yeah, it's a little yeah, it's a
Yeah,
little only 4 plants per person, and then if you 2 or more, then it's 8 plants per household. But what if me and 4 homies now, all smokers and all growers, want to move in together? It's simple to limit them to 2 plants per person, while if I was living alone,
exactly.
I could grow 4.
Yeah.
So there is definitely some concerns, but then there's also some very, very promising leads, like the expungements of criminal records in the past, which goes beyond the Constitutional Court judgment, as the Concord judgment said this does not work retrospectively, which means
Yeah.
if you were arrested for private possession of cannabis, you couldn't now rely on the Constitutional Court judgment because it happened after you. Well,
Yeah.
the new legislation now comes and tries to right some of the wrongs that it has in the past. And I do believe this will take huge pressure off our police force, having much more serious crimes to deal with than a little possession.
Yeah. No, that's true. I mean, it's gonna go. I mean, that was one of the aspects that I noted, that if they do expungement of past criminal records, and it sort of coincides with recently how they passed the laws with kids can't be charged as criminals for
Yes.
possession, which really like
The
struck
High
a
Court in
nerve.
Pretoria, I read that one. That was
Yeah,
just
so
about a week
that's
or two ago.
exactly. So it was really nice to see that they had taken that same kindness mentality and put it onto the bill. But I suppose, yeah, I also need to keep reading into the bill. And I know
Yes.
that your department at Schindler's is also still going to be diving through this. This only came out a couple of days ago. So, take anyone who's seen the bill has noticed it's a few pages long.
Yeah, it's not as easy as the judgment or as well, which is in more simpler terms,
Exactly.
that now it's getting more legal
Yeah.
terms, and yeah, no, I understand
Yeah,
completely.
obviously my background isn't legal, but I try to make the most understanding of it, and it's getting complicated at these points. And yeah, it is nice to know that there is a dedicated
Yes.
place in South Africa, or especially a legal firm that's looking at these legislations as they come out, and keeping their eyes on eyes on the ground, and keeping on the ball with all of the new developments, which is a good peace of mind for most civilians, I suppose.
Yeah. Yeah, but I think it's important to know that this bill is just for the private use. This doesn't really concern the commercial space too much. If you still want to enter that, you're looking at your Section 22C licenses, etc. Because this cannabis bill itself still doesn't allow for the sale of seeds. So clearly, there's still that problem that you can't sell seeds. But on the other hand, you as a private individual are allowed to have as many seeds as you want.
Yeah.
But
And
then
if
again,
you
you're
grow,
only allowed to, when you grow, then certain. Yeah, we'll dive into that another day, because that's going to be a long conversation on that. But yeah.
No, thank you so much. I really appreciate the time and effort going into this. It does mean a lot for the broader community. As I was saying before this, it's it's difficult to make sense of the legal jargon. It's scary to see the social media impact of bills and things that we don't all understand going around and creating hype and people saying this and that. So it's nice to have sort of a very educated response on it. And from my side, thank you so much for the time, and I really appreciate the appointment and all the information. I think it's awesome. Thank you.
Anytime, Andrew, and thanks for having me on your show. Good luck with everything, and I look forward to our next collaboration.
Yeah, very much so. Thank you.
Cool. Thanks, Andrew.
Hey guys, so that was Stefan from Schindler's, and that was their information on the cannabis bill. It's super nice to have access to this information and to be able to convey it to you guys. So let's start some comments below if you have any further questions. We are going to do some follow-ups. We have some access to information from Schindler's, whether it's going to be what to do if we get arrested, what to do, how to get medical licenses. So if there's anything like that you want to know on a real legal perspective, just put it in the comments below and we look at those, and then obviously that curates the way we go forward with our content. And I hope you guys enjoyed the video. I hope you guys learned something from the video, and if you did enjoy it and if you did take something from it, make sure to like and subscribe below. It means the world to us. And till next week or till the next video, peace and love, guys.